Now I'd like to talk about this Superlawyer nonsense. Superlawyer is a website that has arbitrarily decided that if an attorney manages to get $1 million settlement on a case, he's considered a superlawyer. Well, that's just an arbitrary definition. To me, a superlawyer is an attorney that's a powerful advocate for the client. That immediately rules out Preston J. Douglas, but it rules in Kathleen M. Beck. She may be a defense attorney, but she's a superlawyer, all right, because she makes mincemeat out of incompetent attorneys like Preston J. Douglas. So if Preston J. Douglas is a superlawyer, then he must be on a steady diet of green kryptonite, because the legal arguments that were made in the Dr. Holland case are not that of a superlawyer. They are, in fact, that of a pathetic wimp of an attorney. They are that of an attorney who is afraid of confrontation, afraid to use words like fraud, malice, and lies, an attorney who feels he has to twist an entire case around to benefit the defendant just so he doesn't have to be bothered doing any work, confronting any witnesses, or doing anything. I mean, he essentially did nothing. He couldn't even make a phone call. I mean, he couldn't even be bothered calling up Dr. Harupian to discuss the autopsy report. Not only that, after I spoke to Dr. Harupian and he explained the time bomb effect of the operation, I called Dr. Bennett, the head of pathology at Albert Einstein Medical School. I explained the situation to him, that Dr. Harupian says the operation's a time bomb and we had no idea Phyllis had 2 aneurysms. Dr. Bennett told me that they would do whatever they could to help out. And Preston J. Douglas couldn't even be bothered giving him a call to say hello. He was an incredibly valuable resource ready to assist with the case, and Preston J. Douglas couldn't even be bothered giving him a phone call. And the same thing goes with Phyllis's parents. Obviously, Phyllis's parents should have been deposed and asked what happened at Mount Sinai Hospital and her appointments with Dr. Holland. They were the ones that attended Phyllis there. I never met Dr. Holland in person. I spoke to him a couple of times over the phone. I mean, we know what they were told in writing at the hospital, that she had 1 aneurysm, but obviously Mr. Douglas should have elicited more information from them. You know, whether other doctors, what were they telling them? You know, what happened at the appointments? Well, especially at the last appointment that Phyllis had, when she complained to Dr. Holland of the symptoms she was having. Preston J. Douglas couldn't be bothered giving them a phone call to discuss it over the phone. You know what he did? He asked me to ask them if they knew of any further appointments. Again, back to the further appointments. That was it, and he couldn't be bothered talking to them to get any information. He asked me to ask them. That's how little work this attorney done. He can't even pick up a phone to make a phone call. I mean, he literally did nothing for 26 months. It's unbelievable. There is no other job in the world where you could sit around for 26 months scratching your head all day and keep your job. If you have any type of normal job, and you sit around for a day or two, you know, twiddling your thumbs, your supervisor is going to say, is everything okay? I mean, you haven't done anything in the last 2 days. And if a week goes by and the calluses on your thumbs are starting to grow due to all the twiddling you're doing, you'd be fired on the spot. But it appears that the career of medical malpractice attorneys just goes on and on and on. I mean, there are no standards of performance, period. And there's also no regulation. That is a serious problem. There were no associations, or there are no Federal Trade Commission of attorneys or anybody looking out for the welfare of the general public. That I can assure you. The public is on their own to sort this out. There is nothing to prevent Preston J. Douglas from climbing to the highest mountain with a megaphone, proclaiming to the world what an expert he is in the field of medical malpractice law. And he's still doing it to this day. Yes, Preston J. Douglas still blowing his horn to this very day, telling the world what an expert he is. I mean, if you read his resume, which of course was written by none other than Preston J. Douglas, you would naturally think, ooh, this guy must be some sort of hotshot medical malpractice attorney. He was the head of the medical malpractice department at Fuchsburg and Fuchsburg. He was on Court TV and the Maury Povich Show. He has a biology degree. He was the editor of some law journal. He gives lectures on the preparation of complex medical malpractice cases. Yes, Preston J. Douglas states that he gives lectures on that subject. So yeah, we'll get to that in a minute. So if you read that, you would naturally think, whoa, this guy must be some sort of hotshot attorney. And then all of a sudden we have the Dr. Holland case, and there's no way to correlate the way he managed, he butchered and destroyed that with his resume. So it just goes to show you, resumes look good on paper, but that's about it. I mean, all that matters is results. And the results that Preston J. Douglas produced are pathetic. Yes, Preston J. Douglas claims that he gives lectures on the preparation of complex medical malpractice cases. Well, that's a joke and a half if I ever heard one. If ever there was a medical malpractice case where Preston J. Douglas could prove his expertise in the preparation of a complex one, it was the case against Dr. Holland, and all he could do was crap out with a prescription from the family doctor. I mean, it's a joke. The notion that he didn't even read the medical records, so the notion that he even thinks he's qualified to give lectures is a joke. It doesn't matter if a medical malpractice case is complex, simple, or anywhere in between. The very first thing an attorney is supposed to do is read every medical record in the file, and he didn't do that. So the notion that he thinks he's qualified to give lectures is ridiculous. And when people go to these lectures, I mean, anybody can give a lecture about anything. You can read a book, watch a TV show, or attend a course, and then give a lecture on it. However, when somebody attends a lecture given by Preston J. Douglas, and it's supposedly about preparing complex medical malpractice cases, they expect to hear from an attorney who is an actual expert in the field, from an attorney who has a history of actually preparing complex cases like the Dr. Holland case. And they sure as heck don't want to hear from an attorney who has a track record of butchering and destroying a landmark medical malpractice case like the Dr. Holland case, and butchering and destroying it in a horrific manner with totally ridiculous and idiotic prescription from the family doctor legal arguments yet. Now, I'd like to show you something from Preston J. Douglas's attorney profile that he posted on Superlawyers. Preston J. Douglas claims that he meticulously prepares strong cases. Well, that's another joke and a half if I ever heard one. Again, this is the type of self-serving cow manure that the public has to be aware of. Since Preston J. Douglas prepared the case against Dr. Holland, and he now claims that he meticulously prepares strong cases, well, a simple logical deduction indicates that Preston J. Douglas's methodology of meticulously preparing strong cases involves not reading patient files, not deposing any witnesses, not listening to the client, not knowing the law, contacting unnecessary expert witnesses, providing them with incomplete medical records, wasting $2,000 of the client's money, coming to the wrong conclusion on the case, sitting on the case for lengthy and extended periods of time and doing absolutely nothing, writing legal arguments at the absolute last minute, claiming you don't know critical information about your own case, claiming a doctor falsified medical records because he felt guilty, and citing no case law. Yes, that apparently is Preston J. Douglas's methodology of meticulously preparing strong cases. Again, this is the type of self-serving bullshit that the public has to be aware of. And again, there's no regulation. There's nobody to complain to about this pile of crap that he's just dumped on the internet. And that's all it is. It's total nonsense. And do you know what the grand finale to all this was? When the judge issued his ruling, Fuchsberg and Fuchsberg called me up. We met at their offices. Preston J. Douglas read the ruling, which basically dismissed the case. He couldn't get me out of his office fast enough, as if I was somehow wasting his time. Yes, that was the grand finale. He couldn't get the client out the door fast enough. I mean, I'll tell you whose time was wasted. 2.5 years of my time, not to mention $2,750 flushed down the toilet. $2,000 on Preston J. Douglas's useless expert witness, and $750 on an autopsy report that was never even used. I mean, this attorney did nothing the 26 months that he was supposed to do, didn't read the medical records, didn't depose a single witness, sat on the case for lengthy and extended periods of time and did absolutely nothing, waits till the last minute to write his legal arguments, creates a total bullshit story of a legal argument that completely destroys the case, and then when the case gets dumped in the trash can, he can't get the client out the door fast enough, as if it's somehow the client's fault. I mean, to say that Preston J. Douglas is totally unprofessional is putting it mildly, frankly. I mean, Preston J. Douglas's business attitude is an abomination as far as I'm concerned. I mean, this is just one case that we know about that he butchered and destroyed and handled in this manner. In all likelihood, this is his M.O. Why would he treat the Dr. Holland case differently than any other case he ever worked on? I doubt he did. People are creatures of habits. They don't change their spots overnight. They keep repeating the same things over. And as I said earlier, reading the medical records should be an automatic function, but it obviously is not with Preston J. Douglas. So if he didn't read the medical records in this case, there's a good chance he didn't do them in other cases. And then, of course, we're talking about deposing witnesses. in order to properly prosecute this case, every doctor that consulted with Dr. Holland should have been deposed, and that was 9 of them total. Almost all of them filed reports. They all had critical information regarding Dr. Holland's activities, and Preston J. Douglas didn't depose a single one of them. So we can only guess what went on with other cases. And then, of course, we have him rewriting facts and twisting things around and ignoring the medical records. I mean, I don't think that's something they teach you in law school. That's for sure. That's Preston J. Douglas at work there. Yeah, that's no law school methodology. That's the Preston J. Douglas methodology. Now, do you know what Preston J. Douglas's primary excuse is that he thinks somehow explains away his prescription from the family doctor legal arguments that were made in this case? Fraud is hard to prove, according to Preston J. Douglas. This from the attorney, who also states that he gives lectures on the preparation of complex medical malpractice cases, as we already reviewed. Well, any attorney who thinks that fraud is hard to prove is a total disaster, for the simple reason that whether fraud is hard to prove or not is completely irrelevant. All that matters is, what do the facts prove? What Preston J. Douglas has done is he has put form before substance. Since he thinks that fraud is hard to prove, he is not going to prove fraud, even if the evidence clearly indicates fraud is involved, and the Dr. Holland case is a perfect example of that. He would apparently dump an entire case into the trash can, like he did with the Dr. Holland case, and it's an overwhelming case also, all because he thinks fraud is hard to prove. So therefore he has to twist facts around and rewrite the case to make it sound like ordinary negligence. The bottom line is, fraud isn't hard to prove. That's total bullshit. Like everything else Preston J. Douglas said about this case. Fraud is proven every day in the courts in this country. On almost a daily basis, you read about somebody getting convicted of fraud. And what is the number one symptom of fraud? Falsified documents. In virtually every case of fraud you read about, the perpetrators are falsifying documents in order to further their fraudulent goals. And what do we have in the Dr. Holland case? We have 2 surgeons falsifying medical records. And when you throw in a concealed aneurysm and a time bomb operation, the notion that fraud is hard to prove is just a lame excuse for failure, period. The bottom line is, fraud isn't hard to prove. That's total nonsense. We reviewed the medical records in this case. The fraud is totally obvious with or without the consultant's report. What Preston J. Douglas is really saying is, in order to prove fraud and properly prove the case, it requires some actual work on his part, and he is not willing to do the required amount of work, period. He would rather just dump an entire case into the trash can than do some work like read medical records and depose witnesses. That's what's really going on here. Besides, winners don't need excuses, but losers sure as heck do. And Preston J. Douglas is the king of the excuse. If you need an excuse as to why you screwed something up, just be sure to give Preston J. Douglas a call. First, he makes excuses on behalf of Dr. Holland and his associates and even his attorney yet. And then he has to make excuses on behalf of himself. I mean, it's just a totally pathetic situation, frankly. And what really makes Preston J. Douglas a total hazard to be avoided is, all the while that he's engaging in these grossly negligent and incompetent acts, not reading patient files, not deposing witnesses, and everything else we reviewed, he actually thinks that he knows what he is doing, and this makes him a total disaster, because he doesn't hesitate to open his mouth and dish out his garbage legal advice, when in fact he doesn't have a clue as to what he's even talking about. And the Dr. Holland case is a perfect example of that. Everything he said about this case from both a medical and a legal point of view was 100% wrong. He didn't get anything right, period. So just the way you would avoid a huge pothole in the road so you don't damage your car, the services of Preston J. Douglas should be avoided for the same reason, so that your legal affairs don't wind up in the salvage yard the same way the Dr. Holland case did. Any legal advice Preston J. Douglas gives is suspect at best. Sure, he might get lucky and some might a monkey throwing darts at a law book. Frankly, I would sooner trust the monkey throwing the darts than I would trust anything Preston J. Douglas has to say about the disposition of a parking ticket, frankly. Besides, Who wants to deal with an attorney where you have to check with 10 other attorneys to find out if the original attorney is even giving you the right information? Because that's the situation you will be in if you make the mistake and try to deal with Preston J. Douglas. I wouldn't trust anything he has to say, period. He didn't know the law. The entire purpose of going to law school is to learn the law. Granted, this law came out after he went to law school, but that's irrelevant. Preston J. Douglas states he was the head of the medical malpractice at Fuchsberg and Fuchsberg. Well, Fuchsberg and Fuchsberg were presenting themselves to the public as experts in the field of medical malpractice law. You would think the head of their medical malpractice department would be thoroughly familiar with every aspect of his profession, from how to prepare a case to critical case law. He didn't have a clue about any of this. Interestingly enough, Preston J. Douglas was fully aware that in 1975, the statute of limitations for ordinary negligence in medical malpractice in the state of New York was reduced from 3 years to 2.5 years. Yeah, that he knew about, because that particular change in the law fits perfectly into his methodology. Now, instead of having to worry about what happened in the last 3 years, he only has to worry about what happened in the last 2.5, so he has to do even less work than before. The Sukumsky ruling, however, was just 3 years later in 1978. He didn't have a clue about that one. That one doesn't fit into his methodology of sitting around playing tiddlywinks all day. Yet now all of a sudden, if fraud's involved, he may have to look back in the Dr. Holland case 8.5 years. That obviously requires some work, and so he didn't have a clue about that one. And here's another interesting little point about the Sukumsky ruling. One of the appellate judges that affirmed the ruling was Jacob Fuchsberg, Abe Fuchsberg's brother and former law partner. Well, you would think that the attorneys at Fuchsberg and Fuchsberg would not only be thoroughly familiar with critical case law in the field of medical malpractice law, but they would be doubly familiar with it since Abe Fuchsberg's own brother was one of the judges who affirmed the ruling. Nah. Preston J. Douglas didn't have a clue about it, period.